number 46, the people of the state of New York versus Donald Odum.
May it please the court, Stanley Kaplan for appellant, people of the state of New York. Your Honor, this case...
Chair, Mr. Kaplan, to reserve any rebuttal time?
Oh, yes, ma'am. May I please have 1 minute for rebuttal?
1 minute. And Mr. Kaplan, what's the evidence in the record that of this defendant's persistent refusal?
Well, the videotape, which I provided this court, is he was initially asked if he wanted to take the test. He said no. I believe when asked again, he said no. But when the officer said to him, well, these are the ramifications. You can have your license suspended, or you will have your license suspended, and this can be used against you in court. He then, after that, said, okay, I'll take the test.
So is there any real issue about the refusal and its admissibility? Aren't we really just talking about the test results?
Well,
because the only time he refused was before he was ever warned,
that's
right?
true, but there's also another factor, which is a refusal, as courts have indicated, is a consciousness of guilt. And that we feel that when someone refuses to take the test, that is in effect an admission, I'm feeling bad about this, and I don't want to take the test.
But aren't there rules in the statute about the admissibility of the refusal? Why is this different from the circumstances that the statute addresses, the VTF?
Well,
isn't it always a question of consciousness of guilt, in other words?
It is.
Okay, so
it is.
So here you have you have a refusal, another refusal, unwarned, right?
Yes.
Right?
Yes.
So according to the statute, they're not admissible, are they?
Well, under sub F, I don't see why not. There's no time limit on a refusal.
But
Are you
there
saying
had been no
because he
warning.
ultimately
Because there was no
consents?
warning before the refusals.
Well, he refused, and then he did refuse again, and before he consented, he was given the ramifications.
Right, so
but that often can happen.
Don't we then move to the question of whether the test results themselves, whether that consent was voluntary?
Sure.
Okay.
I agree with you, but I don't think it's either or. I think that the consent should allow for the test results to go forward. Here is a .09 blowing in the breathalyzer, but I think that before you get to that point, if someone persists in refusing, I think it's something which it's incumbent upon an officer to ask him, do you know the ramifications? Do you know what will happen? Then if he changes his mind and consents, good. But I think the fact
Isn't that what happened here?
It did.
Oops.
But I think that the fact that he initially refused should not be obscured from the record. I think it's something which indicates that only when he was given the ramifications of what would happen, that he then said yes. And I think that's pertinent. That does indicate that he had an initial unwillingness because of a consciousness of guilt. So I don't think that should be expunged from the record. I think that's part of the history of the case. And therefore, that should be something that's allowed to be admitted for the court to consider, for a jury to consider. So
your position is if it's within the first 2 hours, that refusal is not admissible if it's unwarned, right? But if it's after 2 hours, it is now admissible?
No. The 2 hours means nothing. The 2 hours is only a rule, a procedural rule, where someone is so intoxicated that they cannot discuss.
Where does it say
Where
that?
does it come? Where does it come?
Oh, that comes from case law that I've cited in my brief, that it moved, the history of this rule moved from an additional evidentiary rule back, long time ago, where it was something that within the 2 hours you didn't need a physician because of evidentiary, but then it was moved to 1194, and under that provision, it's a deemed, it says in the statute, it's deemed consent.
So what are the scenarios that you envision under the deemed consent?
Someone is so intox they can't speak. They're semi-conscious or comatose, but they need to get a blood test. In fact, waiting only serves a defendant because blood alcohol diminishes over time. Waiting past the 2 hours is not hurting a defendant,
So the
actually.
police officers in the field are
Yes.
supposed to make a determination as to how intoxicated the person is, and as to whether their level of intoxication renders them able to
That's right.
give consent or
That's
not
right.
consent. But doesn't that defeat the whole purpose of the statute, was to not have the police forcing someone to
No.
take a test?
No, the purpose is that under the deemed consent provision, the law as a procedural matter, not an evidentiary matter, has said that when someone is not responsive, it's in the statute. I mean, and it's been interpreted this way. That's why it's deemed consent, because it can't be given by the subject, because that person...
Or else it's deemed consent because we don't want the police to be making those determinations and having a situation in which somebody's required to submit to a test.
The case law has interpreted that section, which I cite in my brief, as a change from an evidentiary rule to a procedural rule, and that the purpose of it, the deemed consent, is for people who are so intoxicated they cannot offer express consent.
I'm kind of losing the argument here a little bit.
okay,
So
sir.
let's just take a step back. The way I understand it is basically on the cases preceding Robinson and Atkins is what you're
Yes,
talking about,
yes.
correct? All right. And that 1194 2A1 is the deemed consent provision that has a 2-hour limitation.
That's right.
All right. And 1194 2F contains no limitation.
That is correct.
All right. So, and the fact that the 2-hour limitation occurs in a deemed consent provision, and whereas here we have an express voluntary consent, it contains no such limitation.
That's right.
That's the core of your argument, right?
Yes, sir.
Okay.
And so the
All right,
fact
but
that...
doesn't provision
I'm sorry.
F refer to such chemical test? So it's referring back to the 2-hour window?
No.
No?
No.
Then what's the such referring to?
Well, let me, it has been interpreted that 2F, and I've seen this in a number of cases, 2F does not have a time requirement.
Well, no, I'm not,
barren of that.
yes, that was not my question.
Okay,
My question
yeah.
is, you've got the word such chemical test, and as you know, this statute talks about chemical tests that
Yeah.
fall within this 2-hour window, and it talks about compulsory chemical tests, where you need a court order. But F is referring to such chemical tests, which is referring back to the chemical tests that fall within the 2-hour
No,
window.
I don't believe so. I don't believe
I'm
so.
asking you why.
Well, because I
What's the
think,
point of the word such?
well, if you'll give me a moment, let me see if I can go through this. I don't have the, do you have the statute?
Well, it does say such.
Well, I'm not disputing. I mean, you,
Well, hopefully
I
not.
know that you're reading, but my review of these cases, and I've gone through all the cases,
Well, have we ever said otherwise? Let me ask
I
you
don't
that.
think you've addressed, this court has not addressed this issue. That's why it's cardinal that this court, because we have a split between the second department and the first department. And the first department is predicated on outdated law. And it's interesting to note that there's even repudiation by criminal courts in the Bronx, which are not following Odum and are not following Rosa.
Let me ask you a different question, if the
Okay,
Chief Judge
ma'am.
will permit me.
Yes,
Because you've
please.
already hit your red light.
Yes, ma'am.
Where's the authority to request a person to take a chemical test after 2 hours? Where's that authority?
The authority in case law has derived from Atkins, in which they say if you can give express consent, and it's permissible, that by the same token, it would be illogical not to allow a refusal.
So I wasn't being clear. My question is, where in the statute does it say a police officer can ask you after 2 hours to take the test?
I don't think it expressly says that. But I think but sub F, and I'd have to look at the such language, but I have not seen any case. In fact, they all say F is a no time limit provision. And if under Atkins, you can after 2 hours, there's nothing sacrosanct about the 2-hour rule. That has a very limited application, and it doesn't appear anywhere else in the provision, only in the deemed consent provision. And since this court in Atkins has moved past the 2-hour consent rule as sacrosanct, that a refusal should also be permitted. What if someone refuses? They can't hear ramifications of what it would mean. Why is that fair to a defendant? If he says, I refuse, the police should say nothing to him after 2 hours and say, oh, you refuse, that's quite all right. I mean, that doesn't make sense because...
Counsel, a last question
Yes,
for you. Did
ma'am.
the Supreme Court's decision in Birchfield change the statutory parameters of the 2-hour rule?
I am not familiar with that case, I'm sorry.
Where the Supreme Court said that warrantless breath tests are permitted as incident to arrest?
Well, there's certainly, and in our own statute, chemical tests are part of the BTL, part of the provision when police take the person into custody and they are offered the chance for chemical tests. That is certainly part of our jurisprudence. And I don't see any issue that would work against this. The First Department, the critical point I would just leave with, although I did have rebuttal time, but is that there's something radically wrong with a case that where even the lower courts are saying this makes no sense. I provided those cases to this court.
Yes, we have them.
Yes, I know. And they have repudiated them, which is very unusual in a case where something is so outdated, it makes no policy sense why you would do
So isn't it then up
this.
to the legislature to
I'm sorry?
If the legislature, if it's a policy question, isn't it for the legislature then to remove the 2-hour rule?
I think this court can do it. I think this court has the power to say that the Second Department's reasoning is correct. This is a false split. It's based on bad law, and that it should be expunged.
Thank you, Mr. Kaplan. Counsel?
Thank you. May it please the court, Marika Meese, Bronx Defenders, for Respondent Donald Odum. This case falls squarely in line with Atkins and the statutory language. This court has repeatedly recognized that under this statutory scheme, there is a period where a driver is required to consent to a chemical test. That's in the statutory language, and the legislature chose a 2-hour period in that deemed consent provision.
Counsel, I'm sorry, just to go back, I think, to what Judge Stein was asking originally. I had this issue here as there's a refusal, maybe 1 or 2 refusals, and then there is a warning given that if you don't submit to this test, X and Y will happen. 1 in relation to your license, 2 in relation to what they can do with a refusal to submit in terms of being used as evidence. And I thought the issue here was whether that warning was coercive because those things weren't true.
That is the issue, Your Honor, but in
Okay.
order to understand why that is so, it's important to understand
get
the
it.
unique
I
statutory
understand.
scheme.
So there were 2 things. Do you dispute the license part of the warning?
You mean in light of the DMV memo of 2012? I think that memorandum is a reflection that DMV may have changed their internal policy and may suspend refusals. But the DMV cannot override the statutory scheme here that the legislature established, and how during this period, a driver is presumed to consent. So by not taking the test, they are revoking that presumed consent. And it is only within that context that a refusal then has meaning as consciousness of guilt. When you're in the post 2-hour period, as we were here, Mr. Odum had a choice.
Refusal for a second. I'm really more focused on the admission of the test results. So I understand your argument on the license. So going towards can the refusal be used? Because really the only issue I see here is that true or not, right? Because if it's true, then there's no coercion in getting the consent to take the test, right?
Well, Your Honor,
those two things are true.
Right. If the warnings are either misleading or false, then it
Right.
would have an impact on the court's analysis of whether Mr. Odum voluntarily consented.
I agree.
But couldn't the warnings themselves be coercive, because you're saying either you take this test or else? So after you get beyond the 2-hour deemed consent time period, right, doesn't it make the warnings coercive?
Yes, the warnings are designed to be
No matter what it
coercive because that's the statutory scheme. They want people to comply.
So what is the authority for after 2 hours if you say, I'm not taking this test? It's, there's no field test available, it's whatever, they're driving back, they get traffic. By the time they get to the precinct, it's 2 hours and 5 minutes. Now you say, I'm not taking the test. Now that can't be used against you.
Because you're no longer in the period of deemed consent. A driver has a choice. The only reason the refusal warnings are given and the refusal is admissible is because the driver is deemed to consent during that period. And as Justice Rivera pointed out, although the language in subdivision F making refusals admissible does not say 2 hours, it says such chemical test,
So
meaning
what is your
a test administered within
best
the period.
authority?
I'm sorry, Your Honor.
Oh, it's okay. I'm talking over you. What is the best authority you have for the deemed consent provision informs the fact that you can use the refusal? Because there could be a lot of reasons for you to really use a refusal, right? I don't want to take a test. That's kind of consciousness of guilt anyway because you're afraid of the results. But so what is your direct tie? Because you look at the statute, that thing is in one provision. The 2-hour rule is in one provision. It was moved to that provision. I follow that argument. What is your best authority for saying that 2-hour provision goes to the fact that you can use the refusal because of this idea that you really already have consented and you're kind of revoking consent? Or I don't see that anywhere.
Well, Your Honor, the statutory language is plain on its face, and I think it designs the scheme such that you only have a 2-hour period when you're deemed to consent.
But isn't there logic in you have a 2-hour period, you get in a car accident, you're unconscious, and they want to take blood? And you get to suppress that because there's no way you could have consented. So if they get to an accident scene and you're unconscious and they think you've been drinking and caused the accident, they can draw blood and you've deemed to consent. That makes a lot of sense to me read that way. I don't follow putting it into an arbitrary time limit on when you can voluntarily consent or not consent based on this warning that failure to do so could be used against you.
Because reading the deemed consent provision as applying only to incapacitated drivers is wrong. It's not what the statute says, and it's not what prior decisions of this court have said. In Cates, where that provision was discussed, it's the right of refusal that incapacitated drivers do not have. Everybody is deemed to consent. But those who are deemed to consent and are conscious are still asked, do you wish to take the test? And when they say no, that refusal, if persistent and if given warnings, is admissible because it is a revocation of that previously deemed consent. I'm sorry.
Where's the authority to ask after 2 hours?
The authority to ask after 2 hours is just as the police could ask to obtain evidence from anyone. So it's a normal consent. May I search your person? May I search your car? So this statutory scheme, in order to protect both the police and drivers and to balance all of the complicated issues at hand, the legislature chose this to require drivers to consent, but they put a limit on it, and that makes sense. And therefore, the refusal provision is tied to the deemed consent provision.
Right, because if you don't want to be subject to the deemed consent, you just don't drive.
True. And also, the legislature could have put a broader time period on it. They chose 2 hours. That's a reasonable period. But the two provisions have to be read together and the entire scheme. When you're after 2 hours, a driver can be asked, do you wish to take the test? And when they say no, that's it.
And if they say yes, you're not saying that's not admissible.
I'm sorry, Your Honor?
If they say yes at that point, that's admissible or not admissible?
It is, if it's truly voluntary. Then you're in the normal world where judges analyze, is this consent with the rules of Gonzalez and all of the other tools that lower courts have to analyze what happened here? Was the person threatened? Was the person given inherently coercive warnings? And those factors as applied to Mr. Odum suggest that his consent to take this test was not voluntary, because it was based on warnings that were both misleading and false, and that were intended and actually did change his decision from no to yes, where there was no clear statutory scheme that would have been admissible. It would not have been consciousness of guilt. A person's refusal to submit to a search of their body or property in general is not admissible evidence, just like a person's refusal to speak to police. It is only by this unique statutory scheme that was put into place, balancing both the interests of police and not having to coerce intoxicated drivers and have to get consent, that makes this refusal admissible as consciousness of guilt. And this statutory scheme is clear, and it's been interpreted this way by this court before. In addition, Your Honors, the second warning, as appellant agrees, in Bronx County, where Mr. Odum was being prosecuted, was particularly false and misleading, because at that time, courts were uniformly suppressing refusals. And so as applied to Mr. Odum, as well as the language actually used here by the police officer, which was will be admissible in court, as opposed to maybe, makes this decision as to Mr. Odum correct. And the lower courts scrupulously examined these warnings and in context found that they were indeed false and misleading.
Let me ask this. I don't know if it can be done, but can you reconcile the two provisions here? 1194-2A and then 1194-F, I believe. Are they reconcilable?
Yes, Your Honor, because 2A sets out the scheme by which the police can take a chemical test within 2 hours. And during that period, as noted, the driver is deemed to consent. If you withdraw that consent, it becomes a revocation, and that is called a refusal, which becomes admissible under subdivision F.
But I had thought that F had no 2-hour limitation.
It does not, Your Honor, but it says such chemical test, as your colleague pointed out earlier, and that language is in the statute.
Slow down.
Sorry.
Slow down. What do you think such means? The word such means in that context?
I agree with Justice Rivera. In subdivision A says chemical test. Subdivision F says such chemical test. Using the same language, it's the same subdivision, subdivisions of the same statute. The intervening subdivisions have to do with the due process protections that were added to the statute after challenges that people made about this deemed consent provision, like the right to a hearing and due process before license suspension could follow. So the subdivisions must be read in connection with each other, and that there is no additional 2-hour language does not mean that that provision isn't intertwined and related to the 2A provision.
Thank you, counsel.
Thank you.
Counsel? Counselor, can I give you a little hypothetical here for a minute?
All right.
So what if the police knock on your door and they say, we want to search your apartment? And you say, no, I'm not going to let you search my apartment. And the police say, well, I'm going to warn you that if you don't let us search your apartment, we're
Right.
going to arrest you, we're going to incarcerate you, and we're going to get a search warrant, and we're going to search your apartment
Right.
anyway. Now will you consent? Is that if he consents or
think
she
the
consents,
police
is that
can-
voluntary?
I think the police can induce consent if they give them the ramifications of what they're going to do.
So you think that would be a voluntary consent to a search?
If they say, if you do not now, we will arrest you and we will subject your apartment to a search warrant, the person might say, it's in my interest not to allow it. I don't think that is violative. But here, the refusal is something which has no time limit, and I was looking at the
So
statute.
on her hypothetical, what if they knock on your door and say, by the way, we saw that there's a crashed car in front of your house.
Right.
Will you come take a breathalyzer because we want to see if you were driving drunk last night?
No, that would be far afield. I don't think that would be appropriate.
Okay. But, so now they come across them, and it's not the next day, but it's, 5 hours after the crash.
These may be interesting hypotheticals, but they're not the case at hand that this court has to decide. I mean, the issue here is that you can give a refusal.
My concern is that what you're proposing is that just ignore the 2-hour rule, and it means nothing.
The 2-hour rule has no application in any other provision of the VTL. It is limited solely to situation in which there's deemed consent. And why would there be deemed consent? Because the person can't give express consent. That's why in Atkins, this court said we go past the 2-hour rule where a person can give express consent.
Counselor,
but if they can give express
Counselor, take a deep breath.
Okay,
All right.
I got
Go
excited.
ahead.
I'm
Yeah.
sorry, I apologize.
All
But if the person can give express consent, then they also logically should be able to refuse. I looked at the section that Justice Rivera was talking about, and the chemical test merely means the chemical test that's under this provision. I don't think it means the 2-hour rule. And in fact, for...
Well, it is Section 2, correct?
I'm sorry?
It's F of Section 2,
A and
correct?
F of
Well,
2.
yes, but...
Yes.
But,
So it's, excuse me.
Yes,
It's
I'm
all
sorry.
about Section 2,
yes.
correct?
Yes.
All right. So why isn't the reading the one your adversary suggests, which is, these are all subdivisions of Section 2, they're all relating back to 2A, because that's, excuse me,
Yes, I'm
that's the chemical test that all of them are referring to.
Well, we know this is a section involving chemical tests, but Atkins goes past the 2-hour rule. This court has said you can give consent past the 2 hours. If it was sacrosanct, you wouldn't have had that decision.
Well, but in Atkins, they actually consented within the 2 hours.
Yes,
didn't
but we're saying that the mere fact that you give a refusal and then you're given the ramifications doesn't negate your express consent. In fact, Your Honor has said, how can you give 2 hours after? I invite Your Honor to look
Well,
at
it
the
doesn't have to
Morales
bring us
case.
back to the question of voluntariness.
But I don't
After
think
the
it
2
negates.
hours?
It doesn't negate voluntariness. In fact, it says the
That's the
2-hour
question.
rule is where they're too intoxicated to give consent, so it's deemed. It allows police to administer. I gave this court about, okay, I got too excited again. I gave this court about 5 cases or more, Caludro, Ward, Torres, Hurtado, Harbin, where all these cases say what I'm saying. I'm not just saying it. These cases are saying it, that you can give a refusal after 2 hours because it's two sides of the same coin. If you can give consent, then you can give refusal.
Thank
And
you,
if-
Mr. Kaplan.
So, thank you, ma'am.